Mr. Soni.
Thank you, Chairperson. Chairperson, Commissioner Como, Commissioner Gabriel. Today we have, this morning, we are going to lead with the evidence of Mr. Johannes Komotso Pshlane.
Yes.
May the witness be sworn in.
Thank you. General Pshlane, are you going to give your evidence under oath or affirmation?
Under oath, Chair.
Yes. Do you swear the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you.
Mr. Soni.
Thank you, Chairperson. General, you served as Acting National Commissioner from the 14th of October 2015 to the 1st of June 2017, is that correct?
Correct, Chair.
Now, you've been requested to make a statement about your knowledge of TRC matters while you were the Acting National Commissioner. Is that correct?
Correct, Chair.
And you have, in fact, made a statement.
Correct, Chair.
If you look at the file in front of you, starting at page 2372 and ending at 2379, is that the statement you made, sir?
That is the statement I made, Chair.
And if you look at the top of page 2379, there is a signature on top of the word deponent. Is that your signature?
I confirm that is my signature, Chair.
And in addition, do you confirm that the contents of this affidavit are true and correct?
Contents are true and correct, Chair. Thank you.
Now, I want to take you to certain parts of your affidavit, and I want to thank you for helpfully assisting in dealing with matters that are more of a statutory nature than relating to the affairs of the police. And in your statement, you deal with those matters in some detail, and we'll come to that. Now, the request that was made to you in respect of the evidence that you are required to provide, is that set out at 2380? That's just immediately after your statement.
That's correct. 2380 to 2381.
Yes.
Okay.
All right. And there you are requested to assist the Commission in respect of 3.1, your role, responsibilities, and authority as the National Commissioner during the time of your tenure, and any knowledge you may have about TRC matters.
Correct, Chair.
In paragraph 5 of your statement, you say you want to essentially deal with 3 broad matters or broad topics. And the first one is why you do not have knowledge of investigations of TRC matters, notwithstanding that you were the Acting National Commissioner for a period of 20 months.
It's correct, Chair.
And then the second topic is that you explain the statutory changes that were made prior to your ascendancy as National Commissioner, which resulted in the National Commissioner being removed from any oversight of TRC matters.
That's correct, Chair.
And then the third is your appointment and removal as Acting National Commissioner.
Correct, Chair.
All right. Let's deal with the first matter, namely your knowledge of TRC matters, or rather your lack of knowledge of TRC matters. And you start off in paragraph 6 of your affidavit saying that notwithstanding that you occupied several senior positions, including National Commissioner, you do not have knowledge of TRC matters.
It is so. I did not have any knowledge or required to do anything in as far as these matters are concerned.
Now, you've told the Commission that you were the National Commissioner from between 2015 and 2015. What other senior positions did you occupy while you were at in the police service? You deal with that at paragraph 7. Sir.
In paragraph 7, just to name a few,
Yes.
I was appointed to the level of Divisional Commissioner in 2007.
In what
Divisional
section?
Commissioner is like a Deputy Director General. And I was appointed to the post of Divisional Commissioner Personnel Services. Personnel Services has more to do with the human resource function of the South African Police Service. So I was the national custodian thereof, and that was from 2007 until 2010. And I was then redeployed and appointed as the Divisional Commissioner of Forensic Services since 2010 in July until I was appointed Acting National Commissioner on the 14th of October 2015.
Yes.
That doesn't mean that that's my service. I have much more than that. I'm just
Yes.
specifically mentioning the two where I served towards the end of my
But
career.
in none of the positions you occupied during your long years of service were you involved with the investigation of TRC matters in any capacity, whether actually investigating or exercising oversight?
None of those required such, and I say so in paragraph 8 of my affidavit.
Yes.
If I am allowed, I can place it on record that none of the positions that I occupied in the SABC required that I be directly involved in the investigation of TRC cases or exercise oversight thereof. However, I must point out that whilst I was the Divisional Commissioner for Forensic Services, we were requested as the division, because that's where the forensic experts are located, we were requested to assist with exhumations of deceased persons and facilitating laboratory investigations to determine identities of the deceased in respect of TRC cases that were being investigated. But we were not directly involved with the investigation themselves. And I say we as a division,
Yes.
because I did not do the actual laboratory work.
Yes.
There are experts located in that environment who were designated to do so.
All right. Then in paragraph 9, you deal with your duties in principle as set out in when you were appointed acting National Commissioner. You deal with your duties in principle, and you say these are set out in section 11 of the South African Police Act.
It is correct, Chair.
Yes. Chairperson, Commissioners, may I point out that we have asked that the relevant statutory provisions are placed before you so you're able to look at it and mark it, and General Paslana has a copy of it as well. But there would be no need to look at it except for references purposes,
Yes.
because it deals with it in the
Yes.
affidavit itself. Now, Section 11, Commissioner General says that you were, in fact, in your capacity as the head of the South African Police, in command of the entire police service.
It is correct, Chair.
Yes. Now, then you say, though, in paragraph 11, that there are certain other statutory provisions that must be taken into account when one looks at what the ambit of Section 11 of the Police Act is, certainly after 2008. Would that be correct?
It is correct, Chair.
Right. And in paragraph 11, you then refer to certain statutory provisions. Will you outline what those provisions are just for the record? And they are set out in 11A to 11E.
11A to 11E
Of your affidavit.
of my affidavit. Yes, I'll start reading 11 on top, which say that is so on account of the following. 1, Section 205 of the Constitution provides that national legislation must establish the powers and functions of the police service. B, that the national legislation is the South African Police Service Act. C, Section 205(3) of the Constitution provides that among the objects of the police service are to investigate crime. D, in terms of Section 207(1) thereof, the President must appoint a woman or a man as the National Commissioner to control and manage the police service. And E, Section 207(2) provides that the National Commissioner must exercise control over and manage the police service.
And that it is Section 11 of the Police Act which replicates Section 207(2) of the Constitution.
Correct.
All right. Then you say you then deal with, under this big heading of the 2008 and 2012 amendments to the National Prosecuting Authority Act and the Police Act.
Correct, Chair. If I may deal with, in particular, start by paragraph 12.
Yes.
Until 2008, the National Commissioner exercised and managed the entire police service.
Sorry, can I just say, that was in terms of Section 11,
That's correct.
which we've read.
That's correct.
Yes.
However, that state of affairs changed quite dramatically in 2008 and again in 2012 when certain far-reaching amendments were effected to the National Prosecuting Authority Act, number 32 of 1988, and to the South African Police Service Act. Insofar, that's on paragraph 13 of my affidavit, insofar as is relevant to the inquiry being undertaken by this commission, in brief, the overall effects of the 2008 and 2012 amendments were as follows. A, the Directorate of Special Operations, colloquially known as the Scorpions, which was located within the NPA, National Prosecuting Authority, was dissolved by the National Prosecuting Authority Amendment Act, number 56 of 2008, and B, the DPCI was established within the South African Police Service by the South African Police Service Amendment Act, number 57 of 2008, by way of the insertion therein of somewhat lengthy new Chapter 6A which now contains sections 17A to 17L of the Act.
Yes. Can I just stop you there for a moment? If you look at the legislation bundle in front of you, that's the file that contains the different acts.
I have it, Chair.
If you look at page 101 of that, Commissioner, you will see right at the top is Chapter 6A.
Correct, Chair?
Are those the amendments that
Do-
were effected?
Those are the amendments, Chair.
And those amendments go all the way up to section 17K. Section 17L, which appears at page 116.
116. That is correct, Chair?
Yes. Now, if you look at your paragraph 16, Commissioner, you will see there that you refer to an annexure JKP2,
JKP2.
which starts after page 2383. It's not numbered, but JKP2 starts after page 2383 of the bundle. Do you see that?
I see, Chair. It's actually on page 2384.
Oh, you're right. It is on the top. Yes, sorry.
It stretches from that page to page 2414.
Yes. Now, can I ask you, what is that document?
This document, it's a presentation, Chair, that I have ordered our legal and policy division, legal services and policy divisions, to put together. That was now during my acting capacity as the National Commissioner, to put together, which was then presented to the entire management of the South African Police Service, to the what we call the National Management Forum. So in that meeting sits the National Commissioner, the Deputy National Commissioners, the Divisional Commissioners who are at national level, the Provincial Commissioners. In other words, all 9 Provincial Commissioners have a sitting on that forum, and that also will include the national head of the DPCI. So the purpose here was really to communicate and make sure that there is common understanding of the amendments that came into effect, and to make sure that we implement the Act as it was amended without deviations. Like we said, the 2008 and 2012 amendments had far-reaching implications to the policing landscape in the country. So it was important that we are not walking around guessworking what the legislatures had in mind. So this presentation, it simply put what contains what the amendment will be communicating, and what is it that was expected of us.
Can I put it this way? This was a working manual for the different levels of policemen who would be implementing the Police Act as it was amended in 2008 and 2012.
Yeah, now, Council, when you talk about working manual, you're talking to a policeman. So these are instructions, guidelines, directives. So these would not necessarily have been the only document.
No, I
Somewhere,
Yes.
following these amendments, there would have been national instructions, directives, circulars that will sensitize the entire organization on their roles and expectations as envisaged by the legislation.
And that document which you ordered to be compiled was in fact dealing with the effect of the amendments in regard to police operations.
Correct, Chair?
And I take it that that is what the police use for the purposes of determining their powers. For example, you as the National Commissioner would know what the ambit of your powers are and what the limits of your powers are.
Correct, Chair?
Okay. Now, Commissioner, for the purposes of your evidence today, we have decided that that annexure will sit as part of your presentation before this commission, but in effect, we will isolate certain aspects of what's contained in the document and the amendments so that we can summarize for the Commission what the position is following the amendments. In particular, the powers of the Commission and the powers of the DPCR, the Commissioner and the powers of the head of the DPCR.
That is correct, Chair.
Commissioners, may I take this opportunity, because these are legal questions. You will see in the bundle, Commissioners, the statutory bundle, there are two cases that have been included in the bundle. Starting at page 150 is the judgment in Glenister 2. That is the, and I'll come to why it's Glenister 2. And that is the judgment who starts at 150 and ends at 279.
Yes.
That is the judgment that dealt with the 2008, or the alleged unconstitutionality of the 2008 amendments. And it is pursuant to this judgment that the 2012 amendments were effected.
Yes.
Then if you look, Commissioners, at page 281 of that bundle, there is Glenister 1. That is the first case brought before the Constitutional Court by Mr. Glenister. And in this, Commissioners, he challenged the validity of any amendments being made to ensure, or any amendments being made to dissolve the Scorpions or the DSO. Glenister 1 is the judgment which allowed amendments to be made in 2008, because what the court found in Glenister 1 is, given the separation of powers, the Constitutional Court was not in a position to interdict Parliament from effecting those amendments. So that is what Glenister 1 is about.
Yes.
But can I also take this opportunity, because it may assist your reading of how these, or your understanding of how these matters, and I say it with respect, how these amendments took place. In paragraph 13 of that judgment,
Glenister 1.
Glenister 1, so page 289, the Chief Justice, the then Chief Justice, sets out the history of the matter, and in particular the purpose of the amendments. And I want to come to it, but this passage explains it. And what the Chief Justice does is he quotes a passage from the affidavit in support of the amendments. And this is what he quotes the Minister of Safety and Security saying to Parliament. And this is what the Minister said then. We want to place on the table, therefore, a proposal for the creation of a better crime-fighting unit to deal with organized crime, where the best experiences of the Scorpions and the police's organized crime unit will be merged. The best investigators from the two units will be put together under the South African Police Service as a reconstructed organized crime-fighting unit. The Scorpions, in the circumstances, will be dissolved, an organized crime unit of the police will be phased out, and a new amalgamated unit will be created. That, in a nutshell, is what the proposed amendments were, and which the Constitutional Court said in Glenister 1 could not be interdicted. But when the amendments were effected in 2008, a challenge was made to certain aspects of the amendment. And following Glenister 2, the 2008 amendments were further amended by virtue of the 2012 amendments. For present purposes, Chairperson, Commissioners, we don't need to deal with the differences between the 2008 and 2012 amendments, because the document on which the Commissioner relies was produced after the 2012 amendments.
Yes.
So they incorporate everything.
Yes.
To the extent that the differences between the 2008 version of the Police Act and the 2012 version are relevant, they will be dealt with at the appropriate time. But the purpose of the Commissioner's evidence today is to tell us what the position was when he was the acting Commissioner.
And that would have been after all of these amendments.
Indeed, Commissioner, yes. And we've just tried to put it into small pieces so that as the matters involved, there will be a better understanding of what happened during the different times. Now, Commissioner, you've heard what I have said to the Chairperson and the Commissioners of the Commission.
Indeed, Chair.
Right. And in your, in JKP2, you will see that reference is made to the Glenister judgment. Is that correct?
Correct, Chair.
You pointed it out when we went through that document.
Correct, Chair.
And that Glenister, I'm just placing on record, is the Glenister 2 judgment that's being referred to, not the Glenister 1 judgment.
That's correct, Chair.
Okay. Now, pursuant to those amendments, you set out in paragraph 17 what the legal landscape is when you were appointed Commissioner in 2015. Is that correct?
Correct, Chair.
All right. Now, can you isolate, can I make this point that the JKP2 contains most of these amendments that you are going to refer to, but it refers to more from a practical point of view of how police should look at these matters.
That's correct, Chair.
And what you are going to do is you're just going to alert the Chairperson and the two Commissioners about the main amendments that were made by the time 2008, the 2012 amendments were effected.
That's correct.
Okay. So can you start off with paragraphs 17.1? Okay, well, perhaps you should just read paragraph 17 because that gives the context.
Yeah. Thanks, Chair. Maybe before I go there, I just hope that we continue to give practical meaning to the amendments and for members in particular to have that proper understanding of what it means in practice. Because if we stray away from what is contained herein, the actions of the police will be not what the legislation envisage.
Yes.
In essence, and this is contained in paragraph 17, I will go bit by bit
Yes.
until you stop me or the chair orders me to do so. 17, in essence, for the purpose of the issues that I wish to emphasize, having regard to the matters that this commission is required to inquire into, the principal effect of those amendments may be summarized as follows. 17.1, the DSO Scorpions were in effect replaced by the Directorate for Priority Crime Investigations, DPCI, also known as the Hawks.
Sorry, Commissioner, can I, and this is entirely my fault, can I ask you to look at page 101 of the statutory bundle, and I want you to please read into the record the provisions of 17AA. So remember, that's part of chapter 6A that you referred us to earlier.
That's correct, Chair.
Would you read into the record what 17AA says?
It's on page 101, 17AA. The heading, it's applicability of this chapter.
Yes.
It's the provisions of chapter 6A in respect of the mandate of the Directorate apply to the exclusion of any section within this Act.
Right.
So the Directorate here, reference is made to the Directorate of Priority Crime Investigation.
That's the DPCI.
That's the DPCI, yes.
Yes. And in the context of, you remember you said to us that your powers as Commissioner are effectively controlling the entire police service. That now must be read subject to 17AA.
It is correct, Chair.
All right, sorry, I interrupted you.
All right. So
We can start with 17.1 again.
17.1, the DSO, Scorpions, was in effect replaced by the Directorate for Priority Crime Investigation, also known as the Hawks. 17.2, while the Scorpions had been located in the NPA, National Prosecuting Authority, the Directorate Priority Crime Investigation, DPCI, was located as an independent directorate in the South African Police Service, and that's provided for in section 17C1, read with section 17B in brackets, that's capital B in brackets B and Roman figure 2. 17.3, whereas priority crimes were previously investigated by the Scorpions, they are now investigated by the Hawks, DPCI. I think that is important, that investigation of the priority crimes is located within the Hawks, and the TRC cases fall within that scope.
Yes.
17.4, the national head of the DPCI is appointed by the minister. There, I think it's wrong. We say law and order, Minister of Police,
Okay.
in concurrence of the cabinet. Section 17C2 for a fixed term of between 7 and 10 years. And that's section 17 capital CA in brackets A 1B. 17.5, the national head of the DPCI must manage and control members of the Hawks. That's 17C3.
Sorry. While you're there, in regard to the provisions of 17.5 and the provisions of section 11, which says the national commissioner is in overall control, what now is the relationship in regard to the investigation of priority crimes? In other words, who has overall responsibility in respect of the investigation of priority crimes?
That overall responsibility is located with the national head of the DPCI and not within the detectives.
Yes. Who would fall under the national commissioner? Detectives.
Detectives will fall under the national commissioner. With the structure, organizational structure, if you have it before you, there is that organizational structure will depict a matrix. And in that matrix, you will note there is a dotted line from the national head, DPCI, to the national commissioner. A dotted line in any organizational structure resembles, it's more support, it's more a secondary. While you have got a solid line from the national head to the minister of police.
Yes.
So that solid line will represent direct reporting to the appointing authority. And in this case, the national head of the DPCI is appointed by the Minister of the Police. Of course, he will go through the parliamentary process,
Yes.
which will result in the appointment, and even the performance agreement and plan of the national head is between the Minister of Police and the national head, not with the national commissioner. The national commissioner is the appointing authority of the head or the divisional commissioner, detectives who will investigate all other crimes that may not fall within the threshold or the scope of national priority crimes to be investigated by the DPCI.
At the time you were National Commissioner, TRC matters were declared to be national priority crimes.
They were declared, and I believe there is no change. They are still national priority crimes. That's why the competent authority to investigate those crimes is the national head directorate of priority crime investigations.
Right. So
I was on 17.
you've
I
just
just dealt
finished
with
17.5.
17.5.
Yes.
I'm now going to 17.5. No, I dealt with 17.5.
Yes.
I'm now going to 17.6. Among the functions of the DPCI, and this is what we just spoke to,
Yes.
is to investigate national priority offenses or any other category of offenses referred to it by the National Commissioner. Now, maybe I recall, because I've been part of the management for long, at least, even with the first Glen Easter, Glenister judgment, in other words, when the first amendment came into effect, that between the detectives and the Hawks, or DPCI, they had to collaborate and go into an arrangement of setting up the threshold. In other words, which cases will go to the DPCI in line with the amendment and the legislation, yes, and which cases will continue within the investigation, the detective services. And I know even at that point, the first instance when the Hawks was established, most of the members who were located within the detective services, particularly in 2 or 3 environments. One, organized crime, serious and violent crimes, as well as within commercial crimes. Those who were screened and found to be suitable were then relocated from the detective services and went over to as part of the initial establishment of the DPCI or of the Hawks. And there they were joined also by some members who came from the DSO. If you recall, the DSO had a wide range of expertise. Yes. I mean, you had prosecutors, you had auditors, too many specialists, but within that environment, you still had people who were doing investigation. So those that met the criteria to be employed within the Hawks, interdepartmental transfers were effected that resulted in them being appointed within the Hawks environment. In other words, those people may not necessarily have been policemen or policewomen before, as they were part of the Hawks, of the Scorpions, yes, which was located within the NPA. Yes. So then, with that process, appointments were then made through the process that was facilitated, interdepartmental transfers, and they were appointed as members of the South African Police Service. I say so, Chair, with authority, because at the time, I was the Divisional Commissioner, Personnel Services, whose mandate, amongst others, I can simply say, from entry to exit. In other words, Personnel Services facilitate coming in and until retirement and maintenance of the members. I thought I just elaborate a little bit on that one.
Yes. While you on that, when you were dealing with 17.6, and thank you for that, because that, in a sense, is a historical matter that you have first-hand knowledge of, the integration or the establishment of the Hawks in the police and some of the teething problems that would have been experienced at that time. But while you on that, can I say to you, in respect of 17.6, you gave the reference as section 17D. I just want to point out, Chairperson, it should actually read 17D 1B. That's the more relevant part of section 17D. So it's 17D 1B. Yes, sir.
Thank you. May I proceed, Chair? 17.7, the national head of the DPCI determines the fixed establishment of the DPCI and appoints its staff. When we talk about the fixed establishment, you talk about the organizational structure as well as the personnel structure. In other words, what resources do you need to execute that function? So the national head of the DPCI does that. 17.8, no person may be appointed to the DPCI unless he or she has been issued with a security clearance. And I think it talks there to section 17E2. 17.9, in order to facilitate a multidisciplinary approach, the NDPP, National Director of Public Prosecutions,
Yes.
must ensure that a dedicated component of prosecutors is available to assist and cooperate with the Hawks, members in the conducting of DPCI investigations. Remember earlier I said the Scorpions, as it was, had prosecutors and so on. DPCI is not responsible, thus you do not find prosecutors located in that environment. They rely on the capacity which is located within the National Prosecuting Authority. I think this is what it's talking
Can I
to.
just interrupt you there? Chairperson, Commissioners, may I just make this point? That is some of these amendments are 2012 amendments, and one will understand why those amendments came about and the purpose of those amendments by looking at the majority judgment in Glenister 2. The minority judgment thought that the 2008 amendments passed constitutional muster. The majority judgment said that they didn't and recommended how one could bring them up to the constitutional threshold. And it is on account of that the majority judgment that the 2012 amendments came about. And this, in fact, is a replication of what the DSO was doing with the prosecutors, in fact, leading the investigations. And you'll recall what the minister said, as was quoted in Glenister 1, that they wanted this located in the police service. So it is now police-led but assisted by prosecutors. That's
Yes.
as I understand it, the purpose of
Yes.
that amendment.
Thank you for that explication.
May I proceed, Chair? On 1710, Parliament must effectively oversee the functioning of the DPCI. 17.11, the National Commissioner must include in the SAB's annual report to Parliament, in terms of Section 40D of the Public Finance Management Act, a report in respect of the DPCI compiled by the head of the DPCI as a separate program.
Yes. You want to say something about that?
Yes, I may. Chair, I think it's important to mention the following, that this it's in effect happening in that you don't have a separate annual report of the Hawks and a separate annual report of the police. The Hawks, as matters stand, remain within one, in other words, their fund and mandate remains located within one of the 5 programs of the police. And they are a sub-program in program 3, which is investigation. So within that program is the Hawks on their own, and then with the detectives, because that's the broader investigation function of the police. So the budget of the Hawks is ring-fenced by Parliament. In other words, when the budget is allocated, there will be a specific amount dedicated for the core business of the Hawks, which the National Commissioner can't tamper with. It is what the national head of the Directorate Priority Crime Investigation is using in staffing and managing the operations of the DPCI. So important in line with this is that when the annual report is presented by the National Commissioner to Parliament, it will include a submission by the national head of DPCI, and the national head of DPCI does that presentation when it comes to presentation of the programs of the police. The national head of the Hawks presents that specific within the broader presentation or annual report of the South African Police Service.
And he makes that presentation to
He
Parliament.
made that actual presentation. And in terms of 1712, the minister must determine with the concurrence of Parliament policy guideline for the selection of national priority offence by the DPCI's national unit in terms of section 17D1A and in section 17K4 in brackets.
Yes.
All right, that's in a nutshell. Do I proceed with 18?
Well, yes. What I want to ask is, are those, for the purposes of your evidence before this commission, the amendments that you found to be relevant and ought to be taken into account?
In a nutshell, they are, Chair.
Now, in paragraph 18, you make an observation about the independence of the head of the DPCI and its head. What do you say there?
In 18, the provisions I have referred to above make it clear that the national commissioner, does not exercise any control over the DPCI or its national head. I think I earlier alluded to the dotted line and the solid line, that in respect of the DPCI, the National Commissioner supports the national head of the DPCI.
Yes. Now, the amendments say that the DPCI is established as a directorate in the police service, and then it goes on to say, but it has that measure of independence that is set out in some of the provisions of Chapter 6A. Now this could create the impression that these are two separate organizations working totally independently of each other, but you want to correct that broad impression that might be created. You do so in paragraphs 20 and 21.
It is so. If I'm permitted, Chair, let me just go through paragraph 20. First, section 17C1 of the South African Police Service Act established the DPCI as a directorate in the South African Police Service. That means the DPCI is a part of SABC, and its members are police officers. The members of the Directorate Priority Crime Investigation carry the same appointment certificate that a member of the South African Police Service will carry. They carry the same rank as what the member of the South African Police Service will carry. They will go for the same basic police training and investigation courses. Of course, there are other specialized courses that are resident within the DPCI. Second,
This is unlike IPIT. The IPIT officers are not police.
that's correct, Commissioner. IPIT officers are not police officers. I do think they are appointed in terms of the Public Service Act, and police, including those in DPCI, are appointed in terms of the Police Act.
Okay, thank you.
Thanks, Commissioner. Secondly, the DPCI have not been allocated separate police stations. I don't think you will walk around in this country and find a police station, they say this is a DPCI police station. And even crimes, when they are reported at a police station. Traditionally, you called it at the charge office. Today, it's referred to as a community service center. So all complaints get registered at a police station. And they get a case number, a crime administration system number. It is only if that docket falls within the scope and mandate of the DPCI that it is then taken to the DPCI for investigation. But that case will not be removed from the police system. So even investigation, take it through the court process. Once finalized, that docket is to find itself back at the police station for record and archiving purposes. Those dockets do not get lost to the station. So that's the point I'm making here.
Yes.
And I think this makes practical sense, but also economical sense. Imagine we're establishing a DPCI Joburg Central next to Johannesburg Central Police Station. We will be confusing the communities. When people are in distress, they don't want to be stuck in all these other administrative red tape and so on. They just want to get to a police station, lodge the thing, and the police must not say, no, go to DPCI or go to wherever. That's the point we are making here, to say there is no police station that belongs to the DPCI. You do find provincial or DPCI offices in provinces, but some, for example, cascaded further within that particular province, may be located within the district or the cluster for proximity purposes and to be able to cover cases in that particular designated precinct where that requirement is. Accordingly, cases investigated by the DPCI are first reported to a police station, assigned a case number, linked to that police station, and thereafter allocated to DPCI if the offense meet the requirements of a national priority crime.
What you've just
priority
read,
offense.
Commissioner, is a continuation of paragraph 21.
Yes. 22, as those amendments were in force when I was appointed as the acting national commissioner, as I was required to do, I respected the independence of the head of the DPCI and the DPCI during my tenure as acting national commissioner. Accordingly, in respect of the investigation of TRC cases, it is the head of the DPCI who will be able to provide the necessary information specifically related to these crimes.
Yes.
Yeah.
Can I ask you on that score, whilst you were the National Commissioner, did you make a presentation to Parliament on behalf of the SAPS?
I've made multiple presentations to Parliament. It's correct, Chair.
And in respect of the report that is compiled by the head of the DPCI, your report would have contained his report.
That report would have contained the DPCI report, and there is no instance where I was in Parliament dealing with matters relating to DPCI without the national head of the DPCI being present. It does happen from time to time, or it did happen from time to time, that he on his own went to Parliament and addressed certain matters in the absence of the National Commissioner. And there is nothing wrong with that because that is his core business and mandate.
And that's because one of the provisions says that Parliament exercises overall oversight of the head of the DPCI.
Correct. That is so, Chair.
Chairperson, I know it's 11:05. I just have this last bit to finish.
Yes.
May I go carry on?
JP, fine. Yes, you may proceed, Mr. Soni.
So you were talking about Parliament, Commissioner, and Parliament seems to play a role, or the venue seems to play a role in respect of the two matters you now address, namely your appointment as an acting national commissioner and then your removal thereof. You deal with these at paragraphs 23, 24, and 25. Will you tell the Commission how it is that you came to be appointed as the acting national commissioner? Oh, before we do that, can I ask you to address the issue you deal with in paragraph 23, namely the period for which a national commissioner is appointed as set out in the Police Act? You deal with that in paragraph 23.
Thanks, Chair. As I've pointed out, the National Commissioner is appointed by the President in his capacity as head of the executive. Section 201(1) in brackets of the Constitution dictates such. In terms of Section 7 of the South African Police Service Act, the National Commissioner occupies the position for a period of 5 years. I see there it's a shorter period determined at the time of appointment. The term is 5 years.
Okay.
Maybe the shorter period, it's what, situational or circumstances.
Okay.
But he's appointed for a term of 5 years.
Yes.
Okay.
Now let's look at your appointment, and you deal with that, the appointment itself, you deal with it in paragraph 24 and how or when you learnt about it.
Yeah. Acting appointments must never be mistaken to be Hollywood. On a lighter note. 24. At the time, I was appointed as acting national commissioner. On 14 October 2015, I was the divisional commissioner, forensic services. On that day, we were making presentations, in actual fact, as management of the South African Police Service. We were in Parliament led by General Pierre, who was the national commissioner then. And it was in the middle of that presentation on that day, the 14th of October, that we were informed that the national commissioner is suspended. And that notification came through the chairperson. I think at the time it was Honorable Francois Beekman, who announced that the national commissioner is suspended. And then moments later, I was told by the chairperson that that I'm appointed acting national commissioner. So I had to take on that responsibility from that day. It was not strange, because when I was sworn as a young boy in the South African Police Service, there is, in taking our oath, you undertake to serve anywhere, in any capacity, instructed to do so by the powers that be. So on that day, in the middle of I went there as a divisional commissioner, forensic services. I came back, I was told you are an acting national commissioner. And I was able to perform that function until, I note you want to say something.
Before you go on, can I ask you this? The announcement that General Piaga had been suspended was made by the chairperson of the portfolio committee.
Of course, what happened is presentations were going on. As management of the police, we were there. The national commissioner was leading the presentation. I think we were presenting annual reports because it was around October. And so at some point, the office of the national commissioner called her out. And I suspect, because not much was communicated to us then, she then asked to be excused. That was the last time we saw her as the national commissioner. She was called out, and whether she went to the president or whoever, and the decision on her suspension was then communicated to her there. Like I say, Chair, she never returned to the session. But then, for clarity purposes, then that communication filtered through to the chairperson before
Chairperson of the
portfolio committee.
of the portfolio.
Yes, because immediately after that happened, it became breaking news. So the chairperson, and I suspect the powers that be, would have relayed a message to the chairperson to communicate that the national commissioner is suspended. So when it was breaking news, we, at least in that room, got to know that the national commissioner is suspended. So the next person who then could lead the delegation as management would have been the deputy national commissioners. So the chairperson asked at the time, General Sitole, who was the Deputy National Commissioner responsible for policing, to lead the delegation so that we can carry on with what we were presenting. It was a few moments later, I guess the same way that the suspension of the National Commissioner came through to us through the chairperson, that he was also informed that I am appointed as an acting National Commissioner. At the time, there was no paperwork in front of me. I had to take his word of mouth to say, now you are appointed acting National Commissioner.
Can I ask you this? Where was this appointment discussed with you before it was effectively made?
There are certain things I'm not prepared to answer. And that's one of them, because that was done by the executive. The constitution and the act say we serve at the behest of the National Commission, of the President. It is the President's prerogative to appoint a man or a woman. So at the time there was no National Commissioner, and for whatever reasons I was considered, and that was communicated to me. And as a disciplined member, I don't say no to higher authority unless it's something unlawful. I will say no. So in this case, I took the baton and carried on.
So do you assume that the instruction came from the President to appoint you?
Well, at the time, Commissioner, we were in session. So there was no time to say, hey, let me go and hear from the President whether it's correct or not. But following the brief break that we had, there was communication with me by the minister, who then said the President will want to meet up with me. That's the only time in my life I met President Zuma. I went there and I accepted my appointment letter to take the fort as an acting National Commissioner of the police.
What happened to the presentation of the annual report?
Chair, Commissioner, it continued. Remember the presentation, we were already there, and it's programs that were presented. So we carried on and finalized. In actual fact, that day was our last day of presentations. So we carried on, finished the business of the day, and I recall that evening we had to come back, all of us from Cape Town. We were in Cape Town, and we convened, the minister convened a meeting in Pretoria at the police college. 11 o'clock we went into that meeting where he, as the minister, was officially communicating the decision of the President in terms of the National Commissioner was suspended by the President, and then I am appointed as the acting National Commissioner, and that we should work together and lead the organization, which we proudly did.
Thank you. Mr. Soni.
Thank you, Commissioner. So that was your appointment. Now, in paragraph 25, you deal with your removal from the position of acting commissioner. And you tell the chairperson and commissioners how this came about.
You don't want him to read that, 25.
Perhaps you should.
Yeah. Chair, paragraph 25, after serving in that capacity for some 20 months, I was called by the then Minister of Police. In this case, it's the former Minister Fikile Mbalula, to a meeting at his office in Cape Town. I was in Pretoria on that morning. That was on the 1st of June 2017. I flew to Cape Town. Not literally, I did not fly, took a flight, went to Cape Town. And I think I waited for about 2 hours because this was an unscheduled meeting. I did not know that I was to go to Cape Town that day. And after that 2 hours, I think the minister came in. He was with his deputy. And we had a less than 5 minutes meeting. And in that meeting, I was asked, because of the negative publicity and so on, that I should step aside. That's the first time I was hearing step aside in in administration, and I realized, oh, here comes the step aside policy of the ANC. I'm a guinea pig there, of even if I'm not a member there. But step aside was applied on me for the first time. I'm saying I'm not a member because, as members of the South African Police Service, we are supposed to be apolitical, not to associate with any political party, because we are to serve all people.
So you were asked to step aside, and that's what you did.
I was asked to step aside, and my attitude in life is that I'm not glued to any chair. Chair, I have volunteered to join the South African Police Service during difficult times. I may be one of those that are referred to as apartheid police because I joined the service in 1985. But those who refer to me as an apartheid cop, if they are politicians, they are apartheid politicians. If they are teachers who are appointed, then they are apartheid teachers. So
Yes.
I was appointed.
I don't think you need to worry. I don't agree with that characterization that
Yes.
someone, because one of the witnesses asked whether Chief Justice Pius Langa was an apartheid judge because he served long before democracy ushered in. So don't worry about that.
Thanks, Commissioner. Thanks, Chair.
Can I ask a question, please? If your appointment came through President Zuma, how did you understand the situation? The Minister of Police, did he have authority to remove you?
There is no such provision in law for the minister to appoint or disappoint or terminate or fire the national commissioner, be it acting or the national commissioner.
So where did the authority come from?
Out of nowhere, Chair.
Okay.
There is no legislation or policy prescript.
Did you receive a letter from anybody?
To date, I haven't seen a letter.
Okay.
To date. And I'm saying to date, Chair, because that was 2017. And no one has spoken to me on that. But I accepted to step aside because I maintain that I was not glued to any chair. I did not apply to be an acting national commissioner. I applied to be a lieutenant general, a position of divisional commissioner. Just like I did not apply to become the divisional commissioner for forensic services. Yes. I was redeployed. Telephone call, Budi, can you go this place? I thought that they are sending me to go and do something there. Only in the middle of the conversation, I understood this is redeployment. And I accepted it. And I think I've done well.
And I think that takes you to paragraph 26 of your affidavit.
I should perhaps mention the following. When I was appointed acting national commissioner, there was no handover from my predecessor. In addition, given the circumstances of my removal, I was not in a position to make a formal handover to my successor. In actual fact, on the day, that 1st of June 2017, when I was asked to step aside, I asked the minister, who do I hand over to? And he said, don't worry. On my way out, the minister's office in Cape Town is on the 9th floor of that ministerial building. On my way out, I met a colleague of mine, the former, who acted after me, General Mutiba. I was getting out of the lift, he was getting in with the advisor of the minister. And I went to the airport. I was sitting at the airport waiting for my flight back, and I saw a press briefing which he held, and he was introducing him as the new acting national commissioner of the police.
Can I ask you in relation to, and I know when I mentioned to you the unexpected nature of the appointment and removal, you were a bit concerned with the word unexpected, but however one describes it, what effect would it have on the morale? I mean, one knows that, but you've been there, you've been in the personnel section of the police. What effect would this uncertainty about leadership in the police have on morale and efficacy of police services?
Chair, I'll go a little bit back in answering that question. I happen to be the last one to have been appointed as a divisional commissioner by the late Commissioner Jackie Silevi. And I'm mentioning that specifically because at some point he was to be removed. And it is there that I think I had gained a different view of politicians. In this case, former President Mbeki. He called us as management of the police, and he communicated that there are these issues, and he is taking this decision, or he has taken this decision to place Commissioner Silevi on suspension. And in that meeting, that's when he communicated his decision to appoint the former Deputy National Commissioner Tim Williams as the acting National Commissioner. It was beautiful because you understood where the executive is coming from, and he was able, as the Commander-in-Chief, to communicate what the expectations are of the country on us as the leadership of the South African Police Service. So, while it rattled us a little bit, there was comfort. We were able to move on. I think that was the last time that the President did that. Not long after that, a new administration came into office, and
this is the Zuma administration.
Hey, Chair, I don't want to call it the Zuma administration. There was an administration that came into place. That's after the departure of President Beki from office. No, I think at the time, if I'm not wrong, it was
Mutlanthe.
President Mutlanthe who came
Yes.
into office. And you recall in that period, changes were made to the executive, in other words, new ministers being appointed. It was during that time that the late Minister Natim Tetwa was appointed the Minister of Police. At the time, Commissioner Tim Williams was the acting National Commissioner. I think I've said it when I was at the ad hoc to say the instability in the South African Police Service came post the Polokwane conference. Everything went haywire. Because it was not long thereafter that Commissioner Williams services were, as an acting national commissioner, were terminated. And it is now history to know that it's after him that General Peggy was then appointed as a minister. As a national commissioner. Now, all that communication was happening on paper. I'm trying to get to answer your question of what does he do. So, it was,
To the morale.
yeah, what does he do? So, he was then appointed. Fast forward, there were issues. General Cele was suspended. General Mkwanazi was then appointed acting. We all read and know what happened there. At some point, he was removed, and then that's when General Piecha was appointed. So all these, I'm saying, are appointments on paper. Some coming from outside, some coming from within the junior ranks and so on. What does it do to the morale? First thing that it does, it creates instability. It creates confusion. It takes a little bit of time. Here we have now General Masemula out of nowhere is suspended because of
Let's
the
not go there.
PFM.
Let's not go there.
Yeah, what do you think happened with respect to the TRC cases in this time? I know you can't speak to it directly in your capacity as acting national commissioner, but this reduced morale that you speak of, do you have any comments on what this would have done to the TRC cases?
I will not specifically be able to talk to that because it's cases that never came to my attention. It was maybe my understanding that the investigation in respect of those matters will be continuing as it is part of the national priority crimes, and no cases are simply to be closed for the sake of being closed. You investigate. If they are undetected, they are undetected, and you follow due processes in that regard. So,
But you have no personal knowledge.
no personal knowledge at all.
That, Chairperson, is the evidence from our side.
Thank you, Mr. Soni. I think this will be an appropriate time to take a tea adjournment until what time? 15 minutes. Until what time? 10 to. I think this will be an appropriate time to adjourn until 10 to 12.
As you please, Chairperson.
Ms. Moroka, any clarificatory questions for General Patlani?
Address that question to my learned Emperor
Mutwan,
Lekwan.
Lukwan.
Matsele.
Okay, yes, ma'am. Thank you. Is there, Ms. Ranto?
My question relates to your paragraph 26, and it's just for certainty, where you informed the commission about the handover that was not done by your predecessor, and I take it that ought to be General Piecha, right?
Correct.
Yeah. So just for certainty, the one that you never handed over to would have been General Mutiba. Is that
Correct, Chair.
Okay. That's all from my side. Thank you.
Thank you, Ms. Ranto. Mr. Lukele?
Thank you, Chair. No questions for.
Thank you. Anyone online?
Thank you, Chair. No questions.
No questions, Chair.
Thank
No
you.
questions.
Mr. Vani?
Thank you, Chairperson. Just a few questions by way of clarification. General, thanks for coming to the Commission to assist us in important work. Mr. Soni, can I be heard?
Yes,
Okay,
you
good.
are audible.
Correct. So, Mr. Soni, for the evidence leaders, has taken you through the amendments to the SABC Act. And you've pointed out in your statement as well as in your evidence that the amendments to the SABC Act, particularly to Chapter 6A, and in particular Section 17AA, that in respect of the DPCI mandate, the rest of the SABC Act was excluded. So I just wanted to check with you, would I be right in saying that that meant that the DPCI enjoyed full operational independence, particularly in relation to its investigations, and the National Commissioner had no authority to interfere or direct or give instructions in relation to those investigations?
So, Chair, answer one question at a time?
Yes, you
Okay.
may.
Thank you, Chair. Thank you, sir. It is indeed so that the prevailing situation, at least since my time, but I can safely say say before my time as an acting national commissioner, was that the head of the Hawks enjoyed independence. It is for that reason that structurally they have a direct reporting and accounting to the minister and parliament, and that as the national commissioner primarily plays a supporting role and fulfills his or her obligations as provided for in the amendment.
Thank you, General. General, if I can just ask you to direct your answers to the commissioners. Thank you. But would I be correct in saying that those amendments to the SABC Act did not exclude or amend Section 207 of the Constitution, which reads the National Commissioner must exercise control over and manage the police service? So would I be correct in saying that the amendments to the SABC Act did not extinguish that constitutional responsibility?
Chair, no, the amendments did not extinguish or delete that provision of the Constitution, because It is so that we only have got one South African police service, and that the National Commissioner, as provided for in the Constitution, is the overall, manages policing overall in the country. The amendment in the Act only makes it very clear and specific that when it comes to priority crime investigations, those will be the responsibility of the national head, director, directorate, priority investigation, the Hawks. But I went further to say, while the Hawks are there and charged with the mandate, crimes are reported all over the country by members of the community and so on, and that reporting happens at a police station level. So the National Commissioner has got overall command and control of the South African Police Service.
Yes. So would I be correct in saying that if there was, and I'm just putting this up as hypothetical examples, if there was perhaps widespread misconduct in the DPCI, or perhaps systemic failure, would a National Commissioner be in a position to say, look, the Hawks are independent, so I have no responsibility in respect of those issues?
If there is misconduct, Chair, or there is something that is happening not in the spirit of legislation, policy, and otherwise, the National Commissioner cannot fold his arms. The National Commissioner will, of course, just as the Act provides more for the operations, and the National Commissioner still has got some authority, and that's why that dotted line, that's why the matrix, some authority when it comes to support-related issues will include the issue of discipline. But the National Commissioner ordinarily delegates functions. For example, the function of discipline will still be delegated to the national head of the Directorate Priority Crime Investigation. So the National Commissioner can't throw his hands in the air and say, they are the Hawks. They remain members of the South African Police Service located in the Directorate Priority Crime Investigation. Chair, the people who find themselves in the Hawks are some of them coming from within the ranks of the police. If posts are advertised, for example, for promotion and so on, it doesn't prohibit someone in the Hawks to apply, for example, in the detective environment. Similarly, if posts are advertised in the Hawks, it doesn't mean that members of the South African Police Service cannot apply. But my answer simply to the question is, the National Commissioner is not a spectator. You are not going to sit there and see wrong things happening and throw your hands in the air and say, but they are the Hawks. The Hawks are not IPIT. The National Commissioner has got nothing to do, for example, with what is happening in IPIT or in, IDEC, because those are structures. The IDEC is part of the NPA, report to a separate minister. In IPIT is independent, report to the minister. And there is no dotted line to any of those institutions.
Thank you.
Yes, just whilst you are there, just a correction for the record. The IPIT officials are appointed in terms of the Independent Police Investigative Directorate Act number 1 of 2011. I think I must just bring that to your attention. I got you off guard when you said they are appointed in terms of the Public Service Act. They are in fact appointed in terms of that act.
Correct, Chair.
Yes. Thank you, Mr. Vani.
Thanks for that correction, Commissioner. So General, as you say, a National Commissioner, facing systemic failure in the DPCI, he can't throw his hands in the air. He could perhaps do things like call for reports and take steps to remedy the situation, so long as he didn't or she didn't interfere with any operational matters and investigations.
Chair, that's correct.
Thank you. I just want to endorse what Commissioner Como said about officials who served in the police and justice and other departments under apartheid, and that you are correct that there are many individuals who serve with distinction, police officers and prosecutors who protected their communities. So, General, just a few months before you assumed duties as acting National Commissioner in October 2015, the sister of Nokutula Simelane, Tembi Simelane, went to court in order to compel both the NPA and the SAPS to finish their work and to bring that case to a finality. The National Commissioner was the second respondent, and the relief against the National Commissioner was to finalize investigations within 14 days of the granting of the relief. Did that litigation ever come to your attention while you were National Commissioner?
Chair, it never came to my attention.
Thank you. And also, while you were National Commissioner, the historic reopening of the Timol inquest took place. Well, in fact, it started just as you were leaving in June of 2017. Did that matter come to your attention while you were National Commissioner?
Sorry, Chair, you said in June of 2017.
Correct.
I left the office on the 1st of June
On the
2017.
1st of June. Okay, so that wouldn't have come to your attention. But just as a matter of interest, General, since you were head of, or one of your responsibilities was to head up the forensic services, that particular inquest, that death and detention was ultimately solved in that inquest exclusively on forensic evidence through the use of forensic pathologists and an aeronautical engineer. No further questions, Chairperson.
Thank you, Mr. Vani. Mr. Soni?
Chair, so that this issue raised with Commissioner Paslane about when the Commissioner can intervene in matters, I wish to refer Commissioner Paslane to section 17C3, which says, the national head of the directorate shall manage and control all members of the directorate in accordance with the provisions of the Constitution of the Republic, Chapter 6 of this Act, and any other applicable legislation. You see that, Commissioner?
Correct.
Yes. And you understand that whether or not the National Commissioner would be able to intervene in the circumstances described by my learned friend Mr. Vani would have to be determined by a consideration of the entire provisions of the Police Act, in particular the provisions of Chapter 6A.
Correct, Chair.
Those are my questions.
Thank you, Mr. Soni. General Paslane, we thank you very much for having agreed to come and give evidence before this commission. Your assistance is greatly appreciated. You are now excused as a witness.
Thank you, Chair.
Mr. Soni?
Chair, for the further progress of today, may I ask for a 5-minute stand down? The next witness will need to be need to step into the witness box,
Yes.
and somebody else is going to lead
Yes.
her. Chair.
Who's your next witness?
It's Ms. Pillay, Kalyani Pillay.
Ms. Pillay. We'll take a 5-minute adjournment.
Indebted to you, Chairperson.
was requested to assist the Commission and to furnish the Commission with an affidavit that deals with my knowledge of relevant events and matters. In particular, the Commission requested that I set out the following: my role and responsibilities as Director General of the Department.
If you could, though that letter is encapsulated in paragraphs 3.1, 3.2, and 3.3
Yes.
to 4. Is that
Yes,
correct?
that's correct. That's what the
Thank
letter
you.
required.
And then if you can explain paragraph 4 then of what you were requested to do.
Yes, I was requested to submit the affidavit by no later than 25 June 2026, and unfortunately I was unable to file this affidavit timeously due to certain family commitments I had in KwaZulu-Natal. And I humbly apologize, Chair, for the delay in filing this affidavit.
Now, can we then go to who you are? And we find that in paragraph 7 and 8, where you, in paragraph 6, you tell us of your present position, but if you could just give us your brief legal background and where you started and where you are now.
Yes, I'm currently the Acting Director General, but my substantive position in the department is that of a Deputy Director General, Legislative Development and Legal Services, which I occupied since 2013. And while I'm acting as a Director General, Mr. Stephen Ralekwa has been appointed to act as Deputy Director General, Legislative Development and Legal Services. I have qualifications of a BA Law, LLB, and a Master's in Law, and a Master's in Management, Public and Development Management.
What was
I'm
the
also-
LLM in?
It was a general LLM, but specifically on human rights courses. I am an admitted attorney, having been admitted in 1995. I left practice in 2000, and I joined the department on 1 November, and I've worked in various capacities in the department, including Chief Director Legal Services from 2010 to 2013. But when I entered the department, I was employed as a Senior Legal Administration Officer, and thereafter as a Principal Legal Administration Officer in the branch Legislative Development.
Can you please explain the content, as it were, of your position as senior, as a Principal Legal Administration Officer?
The branch Legislative Development deals with the development of legislation, and in the position of Principal Legal Administration Officer, I was responsible for the development of secondary legislation or subordinate legislation, which arises out of the principal legislation that is drafted. But at some stage, the section was streamlined so that all of us did primary and secondary legislation. So it was basically research, drafting of legislation, and promoting legislation in Parliament.
And you're now substantively the Deputy Director General of Legislative Development and Legal Services, which is essentially the head of whatever it is that you were doing in the past.
That's correct, Chair.
And over and above all of that, you're the master of the court. How do they call it?
Yes, I was requested to stand in as the acting chief master following certain changes in the department, and that section deals with the administration of estates.
Is it fair to say you're overloaded?
Yes, it is fair to say that I have a lot of work, but we manage it with the people who are supporting me in my space, but it is a very difficult task having both positions.
If we then move on to paragraph 11, currently what are you doing?
In paragraph 11, I refer to a period between 2017 and 2019 where I acted as the Deputy Director General, meaning the head of the branch Constitutional Development. And I think that is relevant because there's a unit called the TRC unit that resorts under the branch Constitutional Development. And in paragraph 11, the unit that I'm referring to is responsible for the implementation of TRC recommendations in respect of Parliament-approved reparations. And this unit facilitated the payment of individual reparations, educational assistance, and we are currently dealing with housing reparations as well. And I think the link between my work in legislative development drafts the regulations that would give effect to the implementation of those recommendations, and that empowers the payment of reparations from the President's Fund. I know I might be getting ahead of myself, but the President's Fund is a fund that is made up of donations that were paid into the President's Fund for the payment of the reparations. And it is a ring-fenced budget. It's only for reparations in terms of the TRC approved recommendations. And it is reported as its own report separately from the department. And the department does not utilize any money from those funds for its operations or to even run the TRC unit. It's solely for the purpose of reparations. And we cannot implement any reparations without regulations empowering it. So that's the linkage between the two units.
We forgot to mention also in your affidavit that between the periods 2010 and 2012, you're the chief litigation officer in the department. You acted as chief litigation officer.
Yes, it coincided with my appointment as Chief Director Legal Services, which resided in the branch Chief Litigation Office.
We depended on you for briefs.
You depended on the State Attorney for briefs, yes.
So if we move on to paragraph 14, can you read that into the record and then explain 14, 15, and 16?
Okay. So paragraph 14 speaks to my role as Director General. I have no direct role in the prosecution of TRC cases. The NPA operates independently under the National Director of Public Prosecutions, the NDPP. My role is, as Director General, is responsibilities under financial administration support and not investigative or prosecutorial oversight. In terms of Section 36(3)(a) of the National Prosecuting Authority Act, the Director General shall, subject to the Public Finance Management Act, or the PFMA, be charged with the responsibility of accounting for state monies received or paid out for or on account of the prosecuting authority. As part of this responsibility, the budget of the NPA is part of the vote of the Department of Justice, and this includes submission of reports and budgets to the National Treasury Chair.
And in terms of reporting to Parliament, how does that work?
So on occasion, we are called by Parliament to address matters of the budget, and on these occasions, I am supported by the NPA officials themselves. And in this regard, we report on the performance of the NPA against the budget that has been allocated, and we report on what is known as the annual performance plan and the strategic plan of the department. We give Parliament an overview of how we are going to spend the money, and then during the quarterly reporting process and the annual reporting process, we give an account of how we spent the money.
Can I refer you to a document that you were given, I think this morning, under flag number 2. I think the document has been circulated, Chair, and this really is an illustration. The heading is TRC Matters Update, including payments to beneficiaries. And if you go to the second page,
we see that your name is mentioned there. Can you read that into the record?
Okay. Chair, Ms. Kalevani Pillay, Deputy Director General, Legislative Development and Law Reform at the DOJ and CD, told the committee that the department's TRC unit was focused on implementing the TRC recommendations. The unit is working closely with the Legislative Development Branch, also in the department, on developing the draft regulations for housing. It says housing people, I think it's incorrect, but for housing identified as TRC victims, and implementing the recommendations approved by Parliament.
You then, under no, if you turn over that page again, there's your name mentioned at paragraph 5 of 9. It's the third paragraph from the bottom. It's page 5 of 9. It's when you turn over that, you were reading at page 2 of 9, and I'm referring you to page 5 of 9.
Should I read that into the record?
Please, as Ms. Pillay explained.
Ms. Pillay explained how the line items are accounted for. The department has a ring-fenced allocation called the President's Fund, which is made of money donated to for the TRC reparations. The money is accounted for and has its own audited financial statements.
Thank you. If you can then go back to your affidavit. You have explained, maybe you should reiterate at paragraph 20 your relationship with the NPA as the accounting officer for the department. Paragraph 20 of your affidavit.
Correct.
If you could read that into the record.
In my capacity as the acting, it shouldn't be the acting accounting officer, it should be the accounting officer of the DOJ CD. I bear certain responsibilities in relation to the financial administration of the NPA, and in that regard, I render such support as is appropriate in assisting the NPA in its engagements before Parliament.
21.
As the Acting Director General, I possess no statutory authority of oversight in respect of the investigative or prosecutorial functions of the NPA in relation to any matter under its consideration, including TRC cases.
And you mentioned at 22 that you really have no powers or mandate to monitor, coordinate, investigate anything that has to do with prosecutions.
That is correct, Chair.
At 23, you talk about the reporting lines. And you explain that the NDPP reports directly to the Minister of Justice.
Yes, the NDPP reports directly to the Minister of Justice concerning affairs and activities of the NPA. I am not present at those meetings, nor do I attend meetings convened for the purpose of such reporting.
You never get invited?
No, I don't get invited, and I believe that there is a section in the NPA Act that requires that degree of reporting, or that level of reporting, because the minister exercises overall responsibility.
Can I then refer you to another document that was handed over to you this morning and has been circulated? It's at the top of that document pack that you've been given. And it's a memo to Minister Lamola from Advocate Esbatohi. Do you see that?
I do, Chair.
And at the back of that,
Ms. Moroka, we do not have these annexures.
you were given this morning, Chair.
Yes.
My apologies.
Yes.
It's titled to Mr. Lamola, and its subject matter briefing on TRC cases, Chair. At the back of that briefing note, is your signature? If I'm looking at the right document, am I looking at the right document? Are you there, Ms. Pillay? At page 15. There's your name there. Ms. K. Pillay, Acting Director General. And if you look at the signature by Advocate Batohi, it's dated the 2nd of December 2020. I think this is during the stint where you said that short stint of 7 months when you were Acting Director General. Am I correct?
Yes, correct, Chair. That is Annexure 1 you are referring to, Advocate Moroka. And it's not my signature that appears there, it's my name that appears as a person that this memo would have been routed to.
So how does this happen? Or how did it happen?
Well, there was a period of time when, well, not a period of time, there's a process where the NDPP would write directly to Minister Lamola. In relation to this was a briefing on TRC cases. She would have routed it to me, but the memo doesn't reach me necessarily. It goes directly to Minister Lamola, and I did not sign this document. And so there were other matters as well where she would have written to Minister Lamola. For instance, I recall that there were memos that she had written on legislative amendments, which went directly to Minister Lamola. And then he forwarded same to me because legislation fell within my responsibility at the time. And then we would have dealt with the matter and briefed him and given him advice on how we take the matter forward, Chair. But in this matter, this memo did not reach me because it didn't, for some reason, it never got to me.
So you are not aware of this memo?
I'm not aware of this memo. I saw it for the first time today, Madam Chair.
Chair, pleases. So, am I correct in asserting that you receive documentation for signature of whatever nature as a DG that has financial implications over and including the fact that you feed us every day here in this commission?
That is correct, Chair.
So if I were to refer you to the last document in the pack that you're given this morning, how did it come about that this memo came to you? And it is a memo to, excuse me, to Ms. Kubai, and it's a request for approval for the engagement of services in terms of Section 38(1) of the National Prosecuting Act. If, as I understand it, you have nothing to do with prosecution issues.
Yes, Chair. In this regard, Section 38 of the NPA Act provides that the Director of Public Prosecutions, if you look at page 1 of Annexure 3, it sets out what Section 38 is. The Minister of Justice and the NDPP, on behalf of the state, may engage under agreement in writing persons having suitable qualifications and experience to perform services in specific cases and or other related services. So in this regard, this is where the NPA would seek further capacity or expertise from counsel outside of the NPA, and because that has financial implications, that would be routed to me. So if there is a concern that there is no funding, then I would be in a position to raise those concerns under this paragraph.
But it would seem in this instance you were in agreement that the two legal representatives be appointed to assist the NPA.
Yes.
Thank you. If I could draw your attention, well, is there anything else about your affidavit that you want to explain to the Commission that I haven't led you through or taken you through? Possibly more importantly, the terms of reference talk to interference, they talk to delay of prosecutions, they talk to stopping, not delay, stopping of prosecutions. Do you have anything to to say to this commission that would be helpful to this commission? If you have nothing or you know nothing, please say so.
Chair, I have nothing further to add apart from what I've already stated in my affidavit and as per what I've said in my evidence today.
Do you by any chance know about the Rodriguez case?
I've heard of the case, yes.
Were you involved at all?
No, I was not involved.
Were you involved in the Timol inquest?
No.
And in 2007, there was a special dispensation of pardons policy that was set aside. Were you involved in that instance?
I do recall the special dispensation pardon process, Chair, but I became involved when I was appointed as Chief Director, so I was not involved in that case itself. I was required to set out the process to implement that judgment, which required consultation with families and victims, etc., because that's what the judgment required us to do. So we set up that process, and then the process also included the finalization of the recommendations of that special dispensation pardon. And so it took a long time to finalize, but we eventually did finalize them. And we also, I think in the period that I was there, there was a lot of engagement with civil society, was concerned that in the process of consultation, how would we go about it, how would we make it as inclusive as possible. And I think there was a difference of opinion about whether we restart a TRC hearing for those special dispensation, or we conclude it in other more applicable ways that would satisfy the court judgment and that would be appropriate in the circumstances. And I think that's what caused a little bit of delay in getting legal opinions on how to conclude and conclude the matter in a rational basis so that we could give advice to the President on those special dispensation pardons.
I wish to lead you on to something that has not been part of your affidavit, but we do wish to be of assistance to the court. You've been asked for a number of documents, and some of them were classified secret, some of them were classified confidential. I'm assuming some of them would have been extremely secret, or whatever words that are used in that respect. And just to explain to the Commission how that system works, because I also want to refer you to a case. I'm told by Mr. Vani that he was involved in that case, and I had to boast to him that in my other case, I relied on his arguments in that case. So I would want us to talk about Ms. Kepile. If you want to start off.
Yes, thank you, Chair. There's a process in government with regard to the nature of how we deal with documents. There are 4 levels of how we would classify a document. One is restricted, one is confidential, the other is secret, the other is top secret. And all officials in the department must be vetted. And your level of your employment or the nature of the work that you do or the office that you occupy. So you could be an admin officer in the office of the ministry, but you would be required to have top secret clearance. All directors general and deputy directors general must have top secret clearance. So there is a linkage between the nature of the document and the level of the restriction. So unfortunately, I don't have the MIS document in front of me to say, but I do know that top secret documents cannot be emailed, it cannot be copied, and it must always be locked away. And the same applies to locked away in a safe, so it's not accessible to anyone and not left lying on your desk. And the same applies to secret documents. Under confidential documents, I believe the person needs to get permission to then photocopy or release it, but they remain classified under those terms. That is to protect information, but also to protect instances where you want to, where the release of information may harm others. So it has many purposes, but it is an official policy of government that we follow to this day.
And can I then, I think we did give you a copy of the Moseneke judgment as part of the Constitutional Court. And I will refer you to paragraph 49. And, or the name, my apologies, I've been referred to the name of the case, Chair. It's Independent Newspapers versus Minister of Intelligence. And for those who are interested, Chair, Mr. Vani was representing the Minister of Intelligence and others. And I refer you to paragraph 49. If you could read from page 31, where it says the minister draws attention, for the record, please.
Paragraph?
Paragraph 49, Chair.
My paragraph 49 says, I describe briefly.
Yes, Chair, I didn't want to start there. That is why I said paragraph 49, but on page 31, the third line says, the minister draws attention.
Yes.
Thank you.
Okay, from page 31 it says, the minister draws attention to the National Information Security Policy, known as Minimum Information Security Standards, or MIS, which was adopted by Cabinet on the 4th of December, 1998. It applies to all departments of state that handle classified information in the national interest. It provides for measures to protect classified information and empowers the minister to protect information by classifying it as restricted or confidential or secret or top secret. In addition, national legislation and regulations prohibit the disclosure of certain classified information. Thank you, Chair.
And if a document is classified as secret, what then happens? Who declassifies the document?
The person who wrote the document. That's what the MIS requires. If you wrote the document, only you can declassify it.
So there are some documents before this commission that you have declassified?
Correct, yes.
And there was nothing sinister, if I might put it to you, in having classified those documents as secret?
No, not at all.
Chair, having argued with my junior, that is the evidence of misbelief.
Yes, thank you. Ms. Rantu?
Commissioners, there aren't any questions from our side.
Thank you, Mr. Lukele.
No questions, Commissioner.
Sorry, switch off.
No.
People online?
No questions, Chair. Thank you, Chair. No
Thank you.
questions.
Anyone online?
Thank you, Chair. Also, no questions.
Thank you. Mr. Vani?
Thank you, Chair. Just a couple of questions by way of clarification.
Couple means two in English.
Commissioner, I should be skilled in the fact that I need to be more precise with my words. I retract the couple and just say a few. Thank you. Ms. Pillay, I can see from your statement that you wear multiple hats and that you have a very full plate. So on behalf of the families, we thank you for taking the time to come and assist us today. I do want to start actually by going to your supplementary affidavit, which deals with the attempts by the Department of Justice to recover documents for the Commission. And Commissioners, this is in the supplementary affidavit. And I'm referring in particular to the account that Ms. Pillay provides from paragraph 9 onwards, and that's on page 2381 AE. And there, Ms. Pillay, you confirm that in fact documents sought had already been provided to the Commission on 3rd of July 2026, that's in paragraph 9. You also indicate that you've resent those, and then you give a comprehensive account of the attempts by your department to recover the records of the Ginwala Commission of Inquiry. And I can see from this account, Ms. Pillay, that your department that your department has in fact acted with diligence, and you have taken expeditious steps to recover these documents, and we thank you for those efforts. Can I ask, when the documents were provided to the Commission on 3rd July 2026, do you know in what form those documents were provided? So, for example, was it hard copy as well as electronic copies?
I can talk to the process that we follow, Chair. When the documents are located, and I believe this was a batch where we had to declassify certain documents, the documents are copied and we deliver them to the State Attorney, who then delivers it to the Commission. I'm not sure if it was emailed or otherwise, but that is the process we follow, and the documents are delivered by the State Attorney.
Since they were delivered by the State Attorney, I assume you wouldn't know who received them on the side of the Commission?
No, I'm not aware of that.
Okay, thank you. Then if we can turn to your statement, your first statement, and if I can draw your attention to paragraphs 11 and 12, where you speak about as acting Deputy DG in Constitutional Development between 2017 and 2019, a unit was established to help implement the TRC recommendations in respect of the reparations. And in your evidence in chief, you mentioned that a President's Fund had been established, it was ring-fenced. Am I correct in saying that there's some 2 billion rand sitting in that fund which is unspent?
May I respond, Chair? I don't have the exact amount that is currently sitting in the fund, but there is an account of the amount of money we have. What had happened was, this account bears interest, and the department does not spend that interest or utilize that interest for any of its other activities. So the fund has grown, and it's very likely that whatever money is remaining there is arising out of the original investment together with the interest. But we have spent substantial amounts on educational assistance over the years. The numbers that are there are more than 300 million. That's basic education and higher education. We have put a number of children through school and universities. And then we have the 30,000 individual reparation, where we made significant payments, and we recently started a new project to ask those who had not come forward to claim those individual reparations to do come forward, and we are making those payments. We are currently making payments in respect of the housing reparations, and those were recently signed off regulations And I believe at the last stage that I checked, we were at about 48 million that was paid out of this, but that process is still ongoing. So there are amounts that are spent, and I think that information can be readily available in terms of how much we have actually spent. The President Fund actually provides a annual financial statement every year, and that is public information as well.
Thank you. Some of the families who are parties to this commission, as well as other organizations who've also made submissions to the commissioners, have expressed some consternation that after some decades after the establishment of the President's Fund, it does have a substantial sum of money, apparently close to 2 billion, that remains unspent in the face of overwhelming needs that the victims and families have. Do you have a reaction to that?
I think I would like to correct, Chair, that it's not monies unspent. It is monies that are being spent against approved regulations. There is one set of regulations that we have not finalized as yet, and that is on community rehabilitation. And those regulations are currently being drafted. It has also been a difficult process to get them drafted due to the nature of how we intended community rehabilitation to operate. So the monies are being spent. In fact, we continue to spend on the basic education and higher education funding, and as I also indicated, we are continuing to spend on the individual reparations for those who do come forward, but that, I must say, is a small number of people. But whatever is remaining in the fund will go towards further rehabilitation, because there is the aspect of the housing and community rehabilitation to come, still to come. And that will take care of a substantial amount of the funding.
Thank you. Speaking of individual reparations, another concern that the families and the victims have expressed is that it's confined to a very small number of people, just those on the victims list of the TRC, and of those traced, I believe, it's between, we are only talking of a number between 16 and 18,000, and they've asked for certain reforms so that there can be further registration of victims who didn't make it to the TRC. Is that under consideration?
Chair, I didn't want to object because I think these are important issues. Firstly, they're not part of your terms of reference. Secondly, it's not clarification questions.
Yes, Mr. Vani?
I take the point, Chair, although the witness did raise individual reparations herself.
Yes.
At paragraph 11, this unit facilitated the payment of individual reparations, educational assistance, and currently deals with reparations, including housing reparations. I just fasten on that, and I'm not so sure how far one can go with that. Particularly, my interest would be because, as I've pointed out to some witnesses, that it seems, in terms of the terms of reference with constitutional compensation,
constitutional damages, Commissioner.
Damages, we may hit a brick wall. So I thought, Chair, because you have not ruled yet, I thought the witness could help.
Yes, Mr. Vani, let me understand the ambit of the clarificatory question that you seek from the witness.
Thank you, Chair. On the question of individual reparations, she mentioned that this was quite a small amount.
Yes.
And I don't dispute that because the numbers are small. I simply wanted to know whether her department was considering the request to adjust the approach to also include victims who fall outside of the TRC list,
Yes.
but who weren't able to make it to the TRC for various reasons.
Yes. Yes, you may proceed, Ms. Pillay.
Thank you, Chair.
Do you propose enlarging the list?
Not that I'm aware of, Chair. It's a policy issue and it would require the reopening of the TRC process and reopening it to the entire country to identify those people who may want to come forward and to undergo that process again. So at this stage, I'm not aware of any discussion around reopening it.
Thank you, DG. My learned friend asked you about various cases, including the Rodriguez matter and the Timol matter. If I may raise one other matter that was ongoing while you were acting Director General between August 2020 and February 2021, and that was the case of the Cradock 4. The wives of the Cradock 4 launched an application to compel the SAPS to finalise their investigation and to compel the NPA to make a decision in that matter. It was launched a week or two before you assumed your post as acting DG. Did that case come across your desk?
No. No, Chair, it did not.
Thank you. Then finally, if we can turn to the PMG minutes of the Justice and Constitutional Development Portfolio Committee meeting on 17 September 2024. This was a meeting that you attended, and you really responded to some questions. I want to read to you a passage from the meeting summary on the first page. It's the 4th paragraph. So I'll just wait for you to get there. It reads as follows. While the committee acknowledged the enormous complexity and difficulty associated with investigating and prosecuting TRC cases, it was concerned by the slow progress made in processing matters which had delayed the families of those who suffered gross human rights violations obtaining some sort of closure. Do you recall that discussion at that meeting?
There was a discussion in Parliament at the time where the NPA was required to report, Chair, to Parliament on progress it was making on prosecution of TRC cases.
And do you recall whether you were aware of any follow-up that took place thereafter?
Yes, so NPA was called to Parliament on other occasions, but I'm unable to give you specifics on that because that would have been between the Portfolio Committee and the NPA itself.
Thank you, Chairperson. No further questions.
Ms. Moroka, I dare say if there is any re-examination.
Chair, if I may.
Oh, sorry about that, Ms. Rangata.
Sorry for rudely interrupting,
Yes,
Chair.
yes. Thank you, Ms. Rangata, for drawing my attention to your presence.
Thank you, Chair.
Your microphones, you'll get some help.
Good afternoon, Ms. Pillay.
Good afternoon.
Chair, the evidence leaders do not have specific questions to ask.
the reason why I would like to place on record I raised the hand is to put into context the supplementary affidavit of Ms. Pillay for the proper record of this commission and how it arose. Ms. Pillay was, as the accounting officer of the Department of Justice, was served with a subpoena or a summons to provide the commission with various documentation. Ms. Pillay, you confirm that you have received that subpoena to provide the commission with the relevant documents that are important for the work of this commission. Am I right?
I believe that was a subpoena that was a sheriff tried to serve on me personally. I was not in the office, and it was served on the DG's office, which they brought to my attention immediately, yes.
Thank you. I must also commend you because you have been in touch with the evidence leaders in discussing the availability and the difficulties that you have been having in locating the documents. And Chair, she deals with that part of the subpoena in paragraph 6 of this supplementary affidavit.
Yes.
Maybe before I start, I must just recognize and request you to confirm that the document that appears on page 2381 AA, ending on page 2381 AI, is the affidavit, supplementary affidavit that you filed with this commission. Can you find it?
Yes.
2381AA.
Yes, Commissioner. That's at 2381 AA, and it ends on 381 AI, and your signature appears on page 2381 AI. That is your signature, and you confirm the contents of this affidavit to be true and correct.
Yes, correct. That is my signature, and I confirm the contents of the affidavit.
Yes, thank you very much for that. I would like to deal in particular with paragraph 9 of your affidavit, of your supplementary affidavit, where you make the point that some of the documents that have been requested, in particular as contained in the subpoena, has already been provided to this commission on the 3rd of July 2026. You state that in your supplementary affidavit, and you've also confirmed now in your evidence when you have been questioned under clarificatory questions. You still confirm that?
Yes, I confirm that.
I think for progress, Chair, is to make a note that the Commission does not have record of the documents that were submitted on the 3rd of July. Instead, the Commission has a record of documents finished on the 8th of July, 2026.
Are you asking the witness to comment on that?
Yes, Chair, she can comment on that. Do you think perhaps you could have made a mistake, or maybe there was a confusion with the dates?
I think we're going to be very careful how we deal with this issue. There's a document dispute that I didn't want to get into. We submit differently from what the evidence leaders are submitting. I'm not particularly sure why we're going into this, whether it is relevant. From our perspective, these documents were delivered. From the evidence leaders' perspective, these documents were not delivered. Whether anything turns on this or not, I'm not particularly sure.
Yes, but we're interested in getting the response from the witness. Yes, Ms. Pillay?
Chair, as indicated earlier, the process that we follow is that when we locate the documents, we prepare a file, which is a hard copy of the documents. We deliver it to the state attorney, and we request the state attorney to deliver the documents. And these documents were sent to the state attorney because there was a process where I had to declassify certain documents, which I did, and that formed the first bundle of documents that we would have delivered to the State Attorney to deliver to the Commission. And that is as far as I can take the matter insofar as the documents, but
Yes.
from our side, we supplied the documents.
Yes, but
On the 3rd of July.
Yes,
To the state attorney.
yes.
Yes,
Chair-
Ms. Rangata.
Chair, the point has been made. I think we are not going to take it any further. I must state, Chair, that for the purpose of this commission to do its work, it's important and we rely on your kindness and your hard work, Ms. Pillay. You are not under attack, hence you did not receive a Rule 3.3. And the frustration that this commission is facing as various departments, not only the Department of Justice, is the lack of cooperation from various institutions in terms of providing us with documents. These documents are not only required for this commission. Various
The
parties...
question there, Chair.
Chair,
well, Ms. Moroka, no. I'm saying, Ms.
This witness is alleging unlawful, unsupportive conduct on the part of Ms. Pillay. If she says that, she must say it in no uncertain terms. She makes a speech about non-cooperation. Is she saying Ms. Pillay has been uncooperative? That's my objection.
Ms. Moroka, I think Ms. Rangata is still addressing the commission. She hasn't even concluded a statement or question. Ms. Rangata?
thank you for that, Chair. I think for progress, we just need to respect each other as colleagues, and I would prefer that we maintain that. I appreciate that. Ms. Pillay, I was going to refer you to paragraph 27 of your affidavit, where you make a very good point. You say the department is actively searching for the documents that are outstanding for the record of the Tinwala Commission. Documents that have been located have already been provided to the Commission. I commend you for that, and I will still say that we're looking forward to receiving some of the documents that are outstanding. And thank you very much. Chair, that's all that I needed to put on record.
Thank you. Ms. Moroka, any re-examination? Thank you.
Is that Ms. Pillay has really indeed done all her best. She was seen sweeping that room to find documents, and to then make a statement that starts off by saying we don't have cooperation from others is not fair.
Ms. Moroka, that's not re-examination. I've actually asked you to do any re-examination, and you've indicated that there is no re-examination to be conducted on a witness. Ms. Pillay, we thank you for having come before this commission to give your evidence. You are now excused as a witness.
Thank you, Chair and Commissioners. Thank you very much.
Yes. We'll adjourn these proceedings until 2:20 for the next witness to give evidence.
As you please, Chair.
Good morning. Oh, good day.
Chair, we beg leave to call the evidence of Mr. Skosana, and my learned colleague Nalani will deal with his evidence.
Thank you. Advocate Skosana, good day.
Good day, Chairperson
Yes.
and Commissioners.
Thank you. Are you going to give your evidence under oath or affirmation?
Under oath, Chairperson.
Yes. Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thanks.
Mr. Nalane.
Thank you, Chair and Commissioners. Advocate Skosana, you have given 2 affidavits in assistance to this commission, correct?
Yes, Mr. Naran.
If you look at page 2364 of the bundle before you, right there,
Page 2.
2364, I'm sorry. Okay, yes.
Yes, Commissioner.
And then this affidavit starts at 2364 and ends at 2369. And
Yes,
there's
I've
a signature where it says deponent, correct?
Yes.
Whose signature is that?
It's my signature, Chairperson.
So this is your affidavit.
It's my affidavit.
And then the second affidavit is called supplementary affidavit. It appears on 2371A.
Yes,
And on
Commissioners.
on page 2371B, there's a signature there under deponent.
I can see it.
Is that your signature?
It's my signature.
So you confirm this affidavit as well.
I confirm this affidavit, Chairperson.
Thank you. Advocate Skosana, fortunately, the area which the Commission wants to cover with you is very narrow. You've been asked to provide certain information which may assist the Commission in executing its functions on the terms of reference of the Commission. You're aware of that?
I'm aware of that.
And the reason you've been called is at some point in your public/professional life, you acted as the Director General of the Department of Justice, correct?
Yes, correct, Chairperson, for a period of 9 months.
Yes. And the reason why we would need your assistance is because the terms of reference deal with, amongst others, the National Prosecuting Authority, which falls under the Department of Justice. Correct?
Yes, correct.
And so insofar as there may be complaints about TRC cases, about the so-called Truth Reconciliation Commission cases, and insofar as the NPA may be involved or affected, this is why we need your assistance to the extent that you acted as a DG at some point. You understand that?
Well understood, Chairperson.
Yeah. So there's nothing that you are accused of having done underhand, illegally or otherwise. You are simply being asked to provide information to the extent that you have any.
Which I'm willing to do to the extent that it can assist the Commission. Thanks, Chair.
Thank you. Before we deal with the substance of your evidence, just tell the Commission briefly your professional academic background. You deal starting with what you say in paragraph 1 of your affidavit. You can read and talk to that.
Thanks, Chairperson and Commissioners. Let me first apologize for my hoarse voice. I'm recovering from flu, and that's because of the different temperatures in the place I've been, etc. So I apologize for the voice that continue to cause that persistent cough or so. Yes, let me start by saying that I've had quite a long service in the public service, illustrious service of just over 36 years. And during that period, I've served in different portfolios across, or positions across the department. Currently, I'm a member of the South African Law Reform Commission, and also enrolled in the legal practice as a practitioner in the advocate's role. And basically, that's what I do, and provide advisory in terms of policy and governance related aspects. My entirety or my long period in the government have been in the policy space, judicial policy development space. And over this period, obviously, I've contributed to quite a number of interventions that are intended or aimed at transforming the legal system and the judiciary to be where it is today. And we have left behind for others to take the baton forward in terms of that journey. I hold 3 degrees from the University of South Africa, B.Juris, LLB, and Masters, and a doctorate from LLD from the University of Fort Hare. And my study at Fort Hare got its own angle in that before 2024, I'd been a dropout of Fort Hare. I went to UNISA, which basically even tried to went via TEFLO, but did not work out. But I ended in UNISA, who accepted me and obtained 3 legal degrees. And it was always this inclination that I'd failed myself by being a dropout at Fort Hare. So I wrote to Fort Hare to do a doctorate.
Please face the chair, Mr. Skosana. Face the chair.
When you
yes.
face the chair.
Yes. So I went back to Fort Hare and to complete my legal studies. And this is where I am today, and I'm very pleased to have been of, and hope I'll be of help to this commission. Thank you, Chair.
Thank you. And in paragraph 3 of your affidavit on 2365, you deal with the very 2365.
Yes.
Yes. You deal with the various positions that we held in the public service in South Africa, and you say prior to 1 Feb 2022, you served in various positions in the public service in the Republic under the Department of Justice and Constitutional Development, and retired from the public service after you had served 34 years in various capacities.
That's correct, Chairperson.
Yeah, and the nation owes you gratitude for your long service, especially in the legal sector reformation. You also say the last position that you held was that of Deputy Director General for Court Administration. Is that correct?
Yes, and also to state that that I held 2 substantive positions. It was Deputy Director General for Court Services, Court Administration. It was initially Court Services, which was changed to Court Administration during the time of Director General Dr. Mashaban. I also served as the head of policy development. And I held those 2 positions concurrently from 2016, 1st of May 2016, until I retired. Prior to appointment as Deputy Director General Court Services, I was the head of policy development, which I occupied back then from 2009, after the head of policy development, then the late Advocate Bonisiwe Makene was transferred to be the special advisor to the then President Jacob Zuma. And then I took over that position of the head of policy until I was appointed as DTG in 2016 during the tenure of Minister Michael Masuta then.
Thank you. You then deal with the period which might be relevant to your evidence today. You say at paragraph 4 that you were appointed by the then Minister of Justice and Correctional Services, Mr. Ronald Lamola, as acting Director General of the DOJ-CD with effect from 1 May 2020. Is that correct?
Yes, I needed to correct that time period. When I was preparing the affidavit, I was relying on the information that I obtained from the department because of that they would have to check in the archives. So the 120 May was basically the extension of my appointment for the second term. I was appointed acting DG from October 2019 until the end of April, 6 months. And that period was basically intended to allow a process of one, to get the DG of that time, he was already earmarked to be an ambassador in Netherlands. And then it will then lead to a vacancy in the position. It will then be filled by a new DG. Hence, I was appointed for 6 months with the hope that those processes would be facilitated in the 6 months, etc. By the end of April, it was still not complete in terms of the appointment process, and I think the minister extended my appointment with a further 3 months. Hence, I stated that my acting stint in the department has been 9 months as the acting Director General.
Yes, thank you. And unfortunately, this commission has heard from a number of incumbents who held the position of DG before your time. The commission heard from Ms. Sindani, who was DG from 2010 to 2016. You recall that?
Yes, correct. And I
then-
had the opportunity, Chair, to serve with all the DGs that have been before here and some of the ministers.
And then she was followed by Ambassador Madonsela from 2016 to 2020.
Yes, that's correct, Chair.
And as you say in your affidavit at paragraph 4, that Ambassador Madonsela was then earmarked to be appointed as ambassador to the Netherlands.
That's correct, Chairperson.
And during that time when he was transitioning, you were appointed as acting Director General.
That's correct, Chairperson.
And then when did that end?
The first appointment was, as I've indicated, was for 6 months until the end of April. But since the process of recruitment and appointing a successor to DG Mashaban had not been completed, my term was extended, and which ran until the end of July, I think.
And then Advocate Mashabani took over as DG from 2021 until 2026.
Yes, Chair.
You then went back to your substantive position.
That's correct, Chairperson.
Yes. And in between, before Advocate Mashabani became DG, Ms. Pillay also acted for some time as DG.
Yes.
You recollect the period that she acted?
Yes, she acted, in fact, from July, and it was during the height of COVID-19. I had to take leave of absence to attend to health challenges at home. And that's why I interrupted my acting appointment, and Minister Lamola appointed the acting DG college on that period. When I returned, I continued to serve under Ms. Pillay.
Okay, thank you. And then coming to the substance of why you've been called today, the commission has fortunately heard from all these DGs about how the position of DG works in terms of the Public Service Act and what role they also fulfill in terms of the National Prosecuting Authority Act. So we don't need to repeat that. But you emphasize at paragraph 11.1, page 2367, in respect of your role, which you fulfilled as acting Director General. And that seems to be the theme that all the DGs seem to emphasize. And you can read 11.1 and talk to it if you wish.
11.1, Chairperson, it reads as follows. In respect of my role and responsibilities as Acting Director General of the Department of DOJ and CD, I respectfully state that I had no role whatsoever in relation to the TRC cases.
And then you expand on that as to why that would have been so, given the nature of the functions within the ministry at 11.2. Can you read that in the record? You talk about the support which you gave in your day-to-day, in the day-to-day operations of the ministry concerning TRC matters. Read that and talk to it. If you
Thanks, Mr. Nalan, through you, Chairperson. As regards the manner in which I supported the ministry in its day-to-day operations concerning TRC matters, I wish to state that the NPA falls under the executive management and direction of the National Director of Public Prosecutions, NDPP, in terms of its operations. The National Prosecution Authority has exclusive autonomy with regard to its prosecutorial functions, which with the DOJ's mandate solely limited to administrative matters and financial accountability.
Yes. That is in terms of law.
That's in terms of law.
Yes. Then you also expand with that on paragraph 11.3. You say during your tenure as acting DG, you had no mandate or authority in respect of the investigative or prosecutorial functions of the Sergeant Police Service or NPA in relation to TRC cases. Is that correct?
That's correct, Chairperson.
And that would be in line with the functions of a DG in the ministry. Is that so?
That's so, Chairperson.
And also the legislative function of the NPA and the Director of Public Prosecutions.
That's correct, Chairperson.
You then state, I was not involved in any management, administrative, coordination, monitoring, advisory, investigative, prosecutorial, or decision-making functions pertaining to the work of the NPA. You can expand further and read what you say. I wish to further state that.
I wish to further state that the outbreak of COVID-19 pandemic occurred during my tenure as Acting Director General of the Department. As such, my day-to-day role was largely consumed by the role the Directors General of the Security Cluster played in advising the Coronavirus Council and Cabinet on preventative measures to curb the spread of the virus.
And 11.4, you talk about the reporting lines between the NDPP and the Minister of Justice and Correctional Services concerning the activities and affairs of the NPA. Can you read that and talk to that, if you will? 11.4.
Through Chairperson, the NDPP reported directly to the Minister of Justice and Correctional Services concerning the activities and affairs of the NPA. To the best of my recollection, I did not attend any meetings for purpose of such reporting. My only engagement with the NPA during my tenure as Acting Director General was in relation to a consultation with regard to the directions that the Minister was empowered to publish in order to curb the spread of COVID-19 at that time.
And this emphasizes the theme that the DG's position plays administrative and financial support.
That's correct, Chairperson.
Then at 12, you deal with the cases that you may have come across. You deal with the Rodriguez judgment. Can you explain, you can read that paragraph and explain how this came about and in what capacity? But you say it was in your capacity as Deputy Chief State Law Advisor that you came across the Rodriguez case, correct?
That's correct.
Not in your capacity as Acting Director General.
That's correct, Chairperson.
Yeah, please explain You may read the paragraph 12.
The only matter relating to TRC cases that was referred to me closer to my retirement by the ministry was in my capacity as the Chief State Law Advisor and related to a Rodriguez judgment of the Supreme Court of Appeal, SCA. The judgment made reference to alleged political interference in the TRC cases. I prepared a draft memorandum in which I recommended that the minister consider appointing an investigative panel comprising of a retired judge and a senior counsel to undertake the investigation contemplated in the SCA judgment. The draft memorandum I prepared became part of the matters I handed over to my successor when I retired from the department. And just to also elaborate that in terms of the DG's office, etc. Minister has a role of policy and legislative mandate over and above the role of the DG and the department, and that role minister exercises in direct engagement with the judiciary, with the NPA, with the Legal Aid South Africa, etc. So the request that came to me in relation to this judgment was basically based on my support around the policy role of the minister. And I read the judgment and prepared that submission. It is for that reason that it not emanate from a DG's office, but from the ministry. Because the minister would basically seek advice from relevant component within the department in relation to specific matters. If it's a matter of security, IT, etc., policy will then approach the relevant entity within the department, and I was approached in relation to this matter, which was very late in my just before my retirement, and I started with the submissions, etc., but could not process further until it was taken over by my successor after I've left. Chair.
In fact, you elaborate more on that memorandum in regard to the Rodriguez matter in your supplementary affidavit at page 2371A. You have that?
Yes, that's correct, Chairperson.
In particular, at paragraph 4 on page 2371B.
Yes.
You state that you don't annex the memorandum to your main affidavit for the reason that the memorandum had neither been considered or approved by the Director General at the time or the Minister.
That's correct, Chairperson.
Yes. And then that memorandum you attached to your affidavit appearing on page 2371D onwards until it ends at 2371K.
That's correct, Chairperson.
But that memo was prepared by you purely in an advisory position.
Yes.
And at that time you were Deputy Chief State Law Advisor.
Yes, in addition to the DG Court Services.
Okay. And that advice evolved around whether and how to constitute a panel to look into the issues raised in the Rodriguez matter.
That's correct, Chairperson.
And that was your sum total of involvement.
Yes, that's correct, Chairperson.
And then you then deal with, I think, your concluding matters at paragraph 13. Please read that paragraph. On page 2368, are you there?
Yes, Chair. Paragraph 13.
Yes.
Thanks. Through you, Chairperson. Other than what I've said, I've stated under paragraph 12 above, I'm not in position of, nor do I exercise control over any other information capable of assisting this Honorable Commission concerning decisions to proceed with, suspend, discontinue, or otherwise affect the investigation or prosecution of TRC cases during the period of my tenure as Acting Director General or by virtue of my other position I held in the department. Matters of that nature fell outside the purview of my duties and responsibilities as Acting Director General or in my other official capacity.
And as I've said to you in the beginning, we're just covering all angles, possible angles, talking to all persons who may have played one or other role in the hierarchy of government about these matters. So nothing untoward is suggested that you did. But you're saying, even in that capacity that you held, there's no information that you can give to this commission to assist with discharging its mandate.
That's correct, Chair, but there's not any other information other than what I've stated in the two affidavits.
Thank you. Chair, those are the questions for the witness.
Thank you, Mr. Nalane. Ms. Rantu? Or Ms. Muroka? Sorry.
No.
Yes, yes, ma'am. No questions. Thank you, Ms. Rantu.
No questions on behalf of.
Mr. Lukele?
No questions on behalf of the NPA.
Yes, online?
No questions, Chair. Thank you.
Thank you. Online?
No questions, Chair. Thank you.
Thank you. Mr. Vani?
Chair, just a few questions by way of clarification.
Yes.
Advocate Skosana, thanks for coming to the Commission, even in the condition that you're in. We are grateful.
Thank you, Chair.
I just want to raise with you a couple of developments that took place while you were Acting Director General of the Department of Justice between May 2020 and July 2021. We have minutes of a Justice and Correctional Services Portfolio Committee meeting that took place on the 11th of September 2019. And according to the minutes, you attended that meeting in your then capacity as Deputy Director General of Court Services. Now, the committee chair made the following comment in that meeting around the discussion of the unfinished implementation of the TRC report. He stated that 21 years had passed since the report's finalization, that a process could not continue for more than 20 years.
Sorry to interrupt, Chair. Can we maybe get a reference so that we can follow of the minutes?
Yes, Chair, that was circulated by the Secretary a couple of days back, and I understand that a copy was forwarded to Mr. Skosana.
Yes.
Mr. Skosana?
Can we get a reference, please, so that we can follow it in the documents? We don't have it in front of us, so there are many portfolio minutes. We don't know where to find it.
If you have that copy, in the minutes it's page 8, and it's the 4th paragraph on page 8.
Page 8.
I'll just read it again for those who don't have it in front of them. The chairperson referred to the TRC report and said it has been 21 years since the finalization of the report. There could not be a process that lasts more than 20 years. By the end of this term, this has to be completed. So you were at the meeting. Do you recall the discussion on that aspect?
I've been handed over the file from my arrival to. I'm trying to find out where exactly the.
My colleague is going to assist you finding it quickly.
No, I've noted the paragraph, Chairperson.
So do you recall any discussion that happened on that point and whether there was any follow-up?
The first question is whether I attended the meeting. I see immediately after that paragraph, my name appears, which Advocate Kosana replied that the contract of Port Shepstone, whatever, etc. So I was at the meeting. And to the extent that the matter is reflecting the minutes, it was discussed. Yes.
Yes. And to be fair to you, that wasn't your portfolio at the time.
No.
You were in charge of court services.
Yes. In fact, if you go down to on that report, my report, the portfolio committee related to two portfolios I held at that time, one court services DDG and two policy, head of policy. That's why I even reported the issues of the PIC Commission and the State Capture Commission, because from a policy perspective, I played that role of facilitating the commissions in terms of their work and their time frames and their resourcing, etc.
Thank you. Mr. Kosana, when you answer, if I can ask you to face the chairperson of the commissioners. Thank you.
Thank you.
Let's then turn to the period when you were Acting Director General of the Department of Justice between May 2020 and July 2021. Between June 20 and May of 2021, the former TRC commissioners and various families and victims wrote to the President requesting a commission of inquiry into the alleged interference of the TRC cases. So this was shortly after the Rodriguez matter had been finalized. Did you ever come across that correspondence?
No, Chairperson.
The presidency did respond to the correspondence in May of 2021 and said that the matter was referred to the Department of Justice for further attention and reply. That didn't come to your attention, did it?
That would have been after my acting stint. I wouldn't have known about it.
Yes, indeed.
Yes.
Although that was May 2021 and you departed in July of 2021.
Yes, from my substantive positions. So I wouldn't be the recipient of any referral of matters from the Presidential Department.
And while we were on correspondence, in September of 2020, while you were Acting Director General, the Foundation for Human Rights submitted a detailed proposal to various parties, including the Minister of Justice, and the Foundation proposed setting up a dedicated prosecution-led capacity comprising prosecutors and investigators to deal with the TRC cases. Do you recall dealing with such correspondence?
No,
Thank you.
To the best of my recollection, Chairperson, I never came, those discussions and correspondence never reached my side.
And if we can turn to paragraph 12 of your statement. Here you talk about the only matter relating to TRC cases that was referred to me closer to my retirement by the Ministry was in my capacity as Deputy Chief State Law Advisor related to the Rodriguez judgment of the SCA. The judgment made reference to alleged political interference in the TRC cases. So I just want to clarify with you, we've taken a look at the judgment and the SCA didn't use the word alleged political interference. Commissioners, I can refer you to the judgment of the SCA. It is included in that bundle. I've read page 103. And the SCA deals with the question of interference at paragraphs 26 to 30. So, for example, at paragraph 27, the SCA says, I'll just wait for the sirens. The full court rightly recommended a proper investigation into these issues by the NDPP. And at paragraph 30, the ineluctable conclusion in all the circumstances is that political decisions were taken by the executive, which may have affected the investigation and prosecution of the TRC cases. Do you accept that the SCA didn't refer to alleged
Yes,
interference?
Sorry, Chair, may I object?
Yes.
This is skirting on cross-examination. The judgment says what it says. So my learned colleague must put a question that arises from the evidence in chief that has been put, with due respect.
Yes, Mr. Van.
Well, Chair, with respect, that's just precisely what I've done. I'm referring to paragraph 12 in his statement where he says the SCA talked about the alleged political interference.
Yeah,
And it didn't use the word alleged, it referred to the
I
interference.
will allow it.
Thank you, Chair. And the witness has already answered the question.
Yes.
No, okay. Through you, Chair.
Yes.
I can
Mr.
comment.
Skosana.
In my memorandum, I'm not unpicking the judgment. I don't even read the judgment. The inquiry from the ministry was that there was a judgment from the SCA which pointed to this aspect. And it is a choice of words I used in my memorandum to use allege. And I used allege because the SCA says there must be an investigation. Not put that as a fact. It says there must be something that must happen to investigate the issues, etc. So in my own interpretation, the issue that needs to be investigated still need to be confirmed and as a statement of fact, etc. That's why I use that word, but it's basically my choice of the word. I did not quote what the SCA said. That's why I don't even put that wording under inverted commas. It's basically how I articulated in my memorandum.
Yes, and thank you for that clarification. You made reference to a memorandum, although unfortunately we don't have that memorandum, and perhaps the evidence leaders can share it with us. So we were relying on your paragraph 12 in your statement. And indeed, the SCA did support the call for an investigation by the full bench to see whether there had been any violations of the NPA Act. But the NPA was quite firm in those paragraphs that that interference had taken place. And indeed, the NPA had admitted that.
Mr. Varney, just to assist you, in paragraph 6 of Advocate Skosana's supplementary affidavit, he makes reference to paragraph 36 of Minister Lamola's affidavit, which he says is attached as an annexure to that affidavit.
Thanks for putting that out, Commissioner Gabriel. I'm told that we don't have that supplementary affidavit, but I'm not going to suggest that we pause to take a look at it. We will take a look at it in due course. Mr. Skosana, also in paragraph 12, you said you recommended that the minister consider appointing an investigative panel comprising a retired judge and a senior counsel to undertake the investigation referred to in the SCA judgment. Did you have in mind an internal inquiry, or was it a commission of inquiry?
No. Commission of Inquiry I established the basis of the Commissions Act. And that power lies with the President.
Right.
Not the Minister.
Although appointing a judge or a retired judge to an internal inquiry also has its own constitutional implications.
You know, those are two different processes, and it was basically advice given to the chair. It was advice given to the minister. One at that point of drafting a memorandum, etc. There was no contemplation for a commission of inquiry, because a commission of inquiry follows a separate process, which is legislated by the Commissions of Inquiries Act of 1947, read with the Constitution. And in this particular instance, the SCA did not mention Commission of Inquiry, but basically mentioned the need to investigate certain aspects, etc. And I had at that point deemed that it could be one of the viable options for the minister to use Section 7 of the Judges Remunerations Act of 2001 and basically assign a process that would be led by a judge to look into the factual circumstances pertaining to what the judgment have raised. And that is normally been done, and those are not commissions of inquiry. They are basically factual investigations informed by any particular circumstances, in the very same way that we have appointed retired Justice O'Regan to investigate matters pertaining to the COVID-19 data cases. At that time, the former Chief Justice, whatever, we used that section, etc. So it's not a commission of inquiry. It's basically a mechanism provided for in law that the minister can use to establish facts, on the basis of which there can then be a clear guidance on how to move forward. Chair.
Thank you. You're aware that at least part of your recommendation was implemented, I believe a year or two later, when SABC SC, Advocate Sabeza SC, was appointed by the NPA to...
Sorry, Chair. Malene is giving evidence. He must ask first the witness whether he is aware of it. The witness has not thus far said that he's aware of it.
With respect, Chair, I did indeed ask whether he was aware that part of his recommendation had been implemented.
Yes.
So were you aware that part of your recommendation had been implemented with the appointment of Demison Sabeza SC by the NPA to look into these matters?
No, I'm not aware.
Okay.
After I left justice, I focused on separate aspects. Completely. Closed my shop on the DOJ's. Check.
And if we can just move on to July 2021. Now, this was the last month when you were acting DG of Justice. In that month, the Craddock 4 families launched an application against the NPA and SAPS, as well as the Minister of Justice, to compel a decision in the Craddock 4 case. Did that ever come across your desk?
Chairperson, I've corrected at the beginning when led by Mr. Nalani the sequence of the dates of my acting stint. And 2021, I was not the acting DG, and I've corrected that. My acting appointment started in October 2019 to July 2020. So by 2021, I was back in my substantive positions in the department.
I just want to confirm those dates. So your acting stint started October 2019?
Yes, Chairperson.
And completed when?
July 2020.
July 2020?
Yes.
Thank you. In that case, you would have been gone for approximately a year already, so I won't proceed with that question. No further questions, Chairperson.
Thank you, Mr. Vani. Mr. Nalani?
No examination, Chair.
Thank you. Advocate Skosana, we thank you for having come before this commission to give evidence. You are now excused as a
Thank you, Chairperson, and I wish the Commission best of luck in its endeavor to find the truth out of the TRC cases. Thank you, Chairperson.
Thank you. These proceedings are adjourned until tomorrow at 11 o'clock. 11 o'clock.